The bill be now read a second time. I call on member for Maitland.
Thank you, Mr Temporary Speaker. I rise to speak on the Child Protection Working with Children Amendment Statutory Review Bill of 2018. While the Shadow Minister has made an excellent response to the bill on behalf of the Labor opposition, I wish to make some comments about the broader implications raised by the Minister in her second reading speech about the government's framework of dealing with offenders who prey on children and young people. As Shadow Minister for the Prevention of Domestic Violence and Sexual Assault, I am concerned that this is just one of a number of pieces of legislation introduced to this place just in this year alone, which impact on the government's approach to addressing all forms of sexual assault and sexual abuse. Already this year we've seen the St John's College Bill, we've seen the Justice Legislation Amendment Bill, and that now we see this bill. Labor is supportive of any positive steps taken by this government to reduce sexual assault and to protect children and young people from assault and abuse by people who may prey upon them, particularly where they have chosen specifically a mode of employment which provides them with access to those young children. Labor indeed first established the Working with Children check in 1998 under the then Carr Labor government with the introduction of two acts, the Child Protection Prohibited Employment Act 1998 and the Commission for Children and Young People Act of 1998, Part 7. In 2015, the Royal Commission into Institutional Responses to Sexual Abuse examined Working with Children checks nationwide and made, as we've heard, 36 recommendations for all of the Commonwealth and state and territory jurisdictions to adopt, aimed at creating a national framework and consistency across standards. Labor supports the government's aims in implementing the recommendations of the Royal Commission, and we also support any attempts to make better and stronger frameworks and strategies in relation to sexual assault in this state. What I must say, though, is that this government has a broader responsibility to meet its obligations in relation to the reduction and elimination of sexual assault and to protect all children and young people from this abuse. The government sexual assault strategy is, as of this week, 2 years overdue. It was promised on the 15th of October 2015 and we were told that it would be prepared within 6 months. In the intervening 2.5 years, we have had little progress other than consultations on a draft strategy which by all accounts have been widely panned by the sector. The relevance of this issue to the legislation now before the House is that this cannot be addressed in a piecemeal and chaotic, shambolic fashion any longer. For example, if we look at the summary of the bill and Section 6, which amends the definition of child-related work in the 2012 Act, so that direct contact with children must be a usual part of the role rather than more incidental to the work being performed, we need to think about the context of that change. Now, earlier this year, when the Attorney-General introduced the Justice Legislation Amendment Bill of 2018, we were told that there is not an appetite in this House for criminalising those who want to have sex with people who are over the age of consent, so 16 or over, within our schools by people who are employed by those schools unless they are in defined, clear roles such as teaching or deputy principals. There was some move towards having care and protection put into that space, but there was not, in fact, in the Attorney-General's second reading speech, it left the door open for those who are employed permanently within our schools as general assistants, maintenance and administrative people who are not in direct teaching positions to not be subject to criminal investigations on those matters. Now, when we look at this legislation before the House, there is an opportunity here to ensure that while the public education system has very strong codes of conduct around the actions of all staff who work in the public education system, we cannot, and in the briefings I have sought from the Ministers for Education and the Attorney-General and other ministers in this place, there are no consistent and clear overarching standards around this kind of conduct that apply to all schools. And this has been a frustration for me in my role as the Shadow Minister for Prevention of Domestic Violence and Sexual Assault, that when sexual assaults happen within schools, unless it happens in a public school, there appears to be very little recourse for students or parents or anyone else who may be impacted by those assaults to go to address them. And then when we see the criminal factors being limited, which may be correct, but this was an opportunity to have a look at that. So if we look at the Australian Institute of Criminology statistics, there was a study, the report from 2004 regarding misperceptions about child sex offenders. The study by Sullivan and Beach quoted in that report of 2004 says that the study of professional perpetrators found that 15% chose their occupation, e.g. clergy, teaching, childcare, exclusively so they could sexually abuse children. And a further 41.5%, nearly half of those offenders admitted that this was part of their motivation. In addition, Sullivan and Beach also found that most perpetrators interviewed listed several different areas of contact with children, and some have spoken of switching to the voluntary or charity sector to continue abusing as a result of being discovered sexually abusing children in their professional capacity. Now, it is a pretty complex point to get across in the small time allotted for a second read speech, but I think it's clear to say that there are some people who have been in the past and are probably still there in some level who have become clergy, teaching staff or childcare workers in order to gain access to children. It would be naive, negligent and grossly stupid of a government to think that there are not people in other professions which are employed on a regular, part-time or full-time basis permanently with schools who would also have these issues. And we hear about it in the media from time to time, the maintenance worker who worked at the school on a regular basis to get access to children. Now, these are issues that could have been discussed if there was a briefing with the Minister prior to this legislation for either myself or the member for Bankstown, the Shadow Minister, for this legislation. And the Minister stands up in this place all the time and talks about the systemic approach that her government takes to sexual assault and domestic violence. She talks all the time about bipartisanship, but this legislation, in the context of the lack of a sexual assault strategy of 2 years, is a damning indictment of the fact that there is no systemic approach, and the lack of briefing shows there is no bipartisan approach in this space. The member for Mile Lakes spoke on this matter. Obviously, it's quite close to his heart. He talked about the number of sexual assaults that happen from his experience as a police officer that have been related to people who are known to the victims. So the offenders are known to the victims. This again gets to the heart of respectful relationships education, another area where this government is failing. So we are prepared to let people onto our school grounds and not make them on a permanent or part-time, full-time capacity, not make them subject to a working with children check, not give children respectful relationships training so that the people who become familiar to them, and when we look at the statistics around this, I've heard figures quoted of 70% of perpetrators being known to their victims, we are giving them no protection at all. Now, I'm pleased to support the government doing working with children checks. That's fine. But get that sexual assault strategy completed. Make sure that it is comprehensive and it truly protects all people in this state, but particularly the most vulnerable, children and young people, from sexual abuse in particularly places like schools and hospitals and where these working with children checks have been identified as a need. When we talk about administrative burdens, don't forget the cuts to the Office of the Children's Guardians. Mr Speaker, I'd like a small extension of time, please.
The question is the member's time be extended. All those of that opinion say aye. To the contrary, no. I think the ayes have it. The ayes have it.
Yep. So let's not forget, when we're talking about cutting red tape, for God's sake, we're talking about red tape that stops children being sexually assaulted and abused at schools by people they have come to trust. So red tape, I think, is a little bit ridiculous in that situation. And what is the problem with the red tape? The overburden of administration when we look at the 2015 and 16 state budget, where this government removed 82 staff from FACS, which included a cut of 11 jobs or a saving of around $2 million from the Office of the Children's Guardian. Now, due to opposition pressure, that money was restored, but we need to be clear that not only will the Minister come into this place and talk about systems, talk about bipartisanship, but she will not act to cut funding for serious oversight, that she will not quote figures about red tape and overburden or allow her members to do so as a reason to constrain adequate checks, and that she will please, and on behalf of all victims of sexual assault and child abuse in this state, please release a comprehensive sexual assault strategy as a matter of extreme urgency. 2.5 years is too long to wait. Think of every single child, every single person who has been subjected to sexual assault in the last 2 years, that strategy could have helped if it had have been delivered. Thank you.
Mr Speaker.
The question is